we're not going to have a formal meeting, but we are going to facilitate our conversations as we have started with the two of them already. We have had 2 conversations with our authors in which we talked about topics that are trending, especially the impact on authors and the book industry in general. If the copyright amendment bill is passed in its present form, how that is going to affect the authors, and what affects the authors will eventually affect the publishers, because as authors, we are producers of books, and what affects us will affect the publishers as well. So in the first of the meetings, ANFASA reached out directly to authors working in the provinces outside the urban hubs, and especially authors writing both fiction and non-fiction in the indigenous languages. By the time of the second meeting, word had started to spread and more authors from all over the country joined in. And I'm very delighted today that we have joined in for our 3rd conversation with authors. And I wish you the best of luck in the discussions. And I will want to introduce Monica Seeber to start the conversation. So the conversation is officially alive. Thank you.
Thank you, Prof. Chairman, for that introduction. I know that Winston Mohapi, also an ANFASA board member, had something to say, but Winston, will you say it at the end? Because I think that's what you have to say is quite important.
Yes, I think it would be better to say it at the end.
That's fine.
Thank you, Monica.
Thank you. So I'm going to go ahead. Good morning, everybody. As the ANFASA chairman has said, this is the 3rd in the series of conversations with authors by which ANFASA reaches out to authors to air their concerns so that in response, ANFASA can play some part in the development of a stronger writing, publishing and reading culture in South Africa. In the letter of invitation, we made it clear that these conversations are open to all authors, not just to ANFASA members and not just to authors of nonfiction, and that the topic of the conversation would not be confined to copyright. However, right now, we're at a critical juncture. After a long break due to the elections, next week, the Parliamentary Portfolio Committee for Trade and Industry is holding its final discussions on the Copyright Amendment Bill. Their decisions will have long-reaching effects on writing and on your ability to make a living from your work as authors. The committee members are, by their own admission, not experts on copyright, and yet they've been instructed to fix the Copyright Amendment Bill. The previous committee, also not copyright experts, had passed the bill and sent it to the president to sign into law. Time passed, and a new president took office. He declined to sign the bill because he was concerned that some of its provisions might be unconstitutional, and he sent it back to Parliament to investigate and to call for further public comment. By this time, there was also a new committee, but they were no more expert than the last one, and they had to rely on the parliamentary legal advisor to guide them. The parliamentary legal advisor is a central figure in this story because she has the power to tell the committee what to do. And so far, she has told them incorrectly that the president's concerns are unfounded and that they should pass the bill without changing it, despite the destructive effects it will have on you, the authors. Yours is not the only voice that the Parliamentary Committee is expected to listen to. All copyright stakeholders are entitled to intervene, And the group in support of the provisions that will harm writing and publishing have been very active, even holding a workshop for the committee to influence their opinion. Personally, I'm glad not to be in the same position as those committee members who are under such pressure to follow the party line and to pass a bill that has such harmful effects into the future. The coming weeks in Parliament, in the committee's discussions, will have a long-term effect on you and your work. So how can we, the authors, make our voices heard? Well, the first step surely is to be informed, to understand the Copyright Amendment Bill and how it will potentially change South African copyright law. ANFASA is pleased, in fact, we are honored to have present today 2 copyright lawyers. Stephen Hollis is one of the local copyright experts who's been following the bill, and he knows it in fine detail. Andre Myburgh is an internationally known figure in the copyright world. He wrote a comprehensive document of expert advice on the bill, which I'm convinced was the advice that led the president to be concerned about constitutionality, among other deficiencies in the proposed legislation. Andre and Stephen are going to engage in a conversation about copyright, which will, I believe, answer many of your questions. But as copyright is such a complex subject, they may lead you to formulate new questions. I encourage you to join the conversation by virtually raising your hands to speak if there's something you want to add, or if there's something you don't understand or want clarity on. There will also be question time at the end. This is an informal discussion. I shall be facilitating it. I encourage, even urge you to participate by responding to our distinguished guests. No question is too insignificant. Our purpose today is to empower you, the authors, with the knowledge and understanding to defend your rights. So, Stephen and Andre, the airwaves are yours.
Yes, Monica, thank you for that introduction. I'm not so sure how internationally renowned I am. I have been in places, I guess, but certainly the copyright bill has taken up a very large part of the past 5 years, and I think the same goes for Stephen. I think two things to start with. The South African Institute of Intellectual Property Lawyers, of which both Stephen and I are members, made a written and an oral submission to Parliament in July and August, and that submission seemed to attract a lot of attention, a lot of good attention across all party lines on the portfolio committee, if I judge the situation correctly. So it is a bit legal. We are, I suppose, lawyers at the end of the day. We will do our best to extrapolate from the legal points what that means for authors and ultimately what that means for publishing and then for booksellers even. But our points are legal ones. At this stage of the discussion, the points are really limited to constitutionality and compliance with the international treaties. So there is a lot wrong with the bill, but not all of them are constitutional issues, because it's not unconstitutional to pass a bad law, but it is constitutional to take away rights and to take away property without some form of justification. So I think what we'll do is we'll start this conversation based on the Institute's submission, both the written one and the oral one. And I think at the end, a lot of the documentation that Stephen and I have generated, both in our capacities for the Institute and also otherwise could be made available. I think many of you have already seen it. So, you know, we wrote the submissions. We also put the odd article up on the Adams and Adams website. And I've written the odd article in Mail and Guardian and elsewhere. The second point of departure I just want to make is that I speak in my personal capacity. I'm not employed by anyone, and I'm not employed by anyone to take any specific position. So I'm not reporting the particular views of an organization or anything like that. To put it in Afrikaans, that we all seem to be speaking, die portfolio committee het het goed gedink. They thought it well to call me an expert. I think in that sense, I did, at the time, I was employed, but, and I think that was part of the expert process, because all of the other experts were also employed by various organizations. But as experts, we made impartial comments of a legal nature on the bill. And I think, Monica, you pointed out that mine was, shall I say, rather voluminous. So I think with those 2 points of departure, I'll hand over to Stephen for introductory comments.
Thank you, Andre, and hello to everyone. Thank you for the kind invitation to participate in today's program. I think as a starting point, Andre is quite right. This topic is very technical, and it's something that the recent parliamentary, actually the entire process has shown, has been a deep misunderstanding, not only right from the beginning of the drafting of the bill, the first version of the bill. The product was a highly defective product, mainly due to that there was a lack of understanding of how all of the creative industries function, not only the book publishing space, but the filmmaking space, the music industry, the computer software programming industry, etc. So the drafters of a bill that is as complex as the Copyright Act, that purports to amend the Act substantially, need to have a proper understanding of not only how copyright functions, but also how business is done in each different sector and subsector of the creative industries that are affected by the changes. And for people to understand that, they need to be either highly experienced in copyright law, or they need to engage with the stakeholders in the different industries before putting pen to paper on the first draft version of a bill. Otherwise, difficulties can arise. And in this instance, significant difficulties arose as a result of that lack of understanding. Of course, what should inform any legislative process, especially processes where people's rights of property are concerned, authors' rights, and also rights in respect of how trade and business can be done in any sector, needs to be informed by a proper socioeconomic impact assessment study. This is in terms of government's own internal guidelines, and also the National Policy Development Framework, which President Ramaphosa signed and Cabinet approved in December of last year. Now, what that requires is, before you start with the process of drafting, proposed legislative amendments, you have to do an economic assessment to see how are your proposed changes going to impact on the market. How are your proposed changes going to impact on the market for, today we're going to speak about authors and publishers specifically, but do bear in mind that the Copyright Act, like I said, affects so many different industries, which makes it even more important for proper impact assessments to be done in respect of each and every different sector and subsector to ensure that that you get it right. Now, to date, we haven't seen a proper economic impact assessment study. I believe the DTI attended to a SAIS report that was unpublished. So to date, we haven't seen a report that performs an analysis of how any of the legislative proposals were actually measured up to see what would the economic impact be. The only economic impact assessment that I saw personally relating to how the proposed changes in the bill, and we'll get to that in a moment, but the proposed changes that would not only slightly change the landscape, but actually turn the tables on how business is done in our copyright sectors, how authors can protect their rights, how authors can earn and make a living from their works. It turns it on its head without any justification. So if you look at, so what is necessary when a decision is made? If government decides to make a decision that it wants to turn the tables on the existing legislative framework, it's even more important to show the justification that supports that. So in this instance, it was even more important for an economic impact assessment to be produced of real quality and value that stakeholders can engage on. During the August 2017 parliamentary hearings, Andre, if I recall correctly, it was you who handed the document that PASA commissioned the PricewaterhouseCoopers to do an assessment of how the new exceptions to copyright and the introduction of fair use would likely impact on the book publishing industry and the ability of authors to protect and monetize their works. And that assessment revealed dire consequences. Quite disappointingly, the previous portfolio committee elected not to engage on that document at all. I can't recall that it was ever referenced again, or that it was disputed, or that a document was actually produced to provide an alternate view. So what we saw recently in the recent public hearings was an invitation by the new portfolio committee under the current parliament to stakeholders, to the public, actually, to come forward and inform of why the president's reservations on constitutionality have merit. Now, to date, in the absence of any legal opinion from experienced legal counsels who are experienced intellectual property and copyright lawyers, and also no economic impact assessment, it was now then possible for the public to step forward and to perform those analysis and provide that to the portfolio committee in the allocated 4 weeks. I think a 1 week extension was allowed, and that 1 week extension fell squarely within the time of unrest in the country that occurred, that rocked the entire country. And despite a number of requests, there wasn't any further extension allowed. So now, many months later, the portfolio committee is again set to continue with its further deliberations in the month of November. But we can only hope. To date, it's still the biggest stumbling block is there is no economic impact assessment to show how these changes, these drastic proposals, are going to impact and how they are justified, how they are justifiable. So I think before we go into what those changes are, I just want to make a brief comment to the authors in the room about how important copyright is, so that there's no confusion about what copyright does for you as an author. Copyright is ultimately can be seen as a set of exclusive rights. Copyright is a creature of statute. What that means is that if you as an author create an original work that's recognized in the Act as a literary work, whether that's a poem, a novel, a research output, if you create a literary work that's original and you reduce it to material form, copyright arises automatically. You don't need to go and register it at an IP office. And the moment these qualifying conditions are met, you get exclusive rights. You can almost see it as, when one thinks of intellectual property, it's intangible assets. But every book that you write, every poem that you write, every line of that you write almost in a literary work, gives rise to an intellectual property asset. And as an author, you need to understand that you are the owner of that asset, and that asset is property. And that property right is recognized in the Copyright Act, and it's also recognized in the Constitution. Now, when you and I think I envy creatives. As a lawyer, if I want to invest in a separate property, I'll have to save up a long time to do so and invest in a physical property. For creatives and for authors, every time you create a copyright protectable work or piece or literary work, you can almost see an invisible house arising, and there's your book. You own that property, it's your building. That building, you've got the keys to the front door, and when you walk into the front door, you can imagine there's various rooms, and you can decide who to let into that room to help you to actually make money from that house. You can almost see it as renting out certain rooms to various parties. So if you're an author of a book, you can decide who to let into the room that helps you to publish the book. You can decide who to let into the room that helps you to distribute the book. You can decide who can actually make the work available in other formats. Now, when you actually, through law, have, and this is what the Copyright Amendment Bill seeks to do, is to introduce new copyright exceptions that will effectively mean that somebody else can have a skeleton key and walk into your house at any point of time not even during the night, like a thief in the night, but every time, even broad daylight while you're there, walk in and walk out with your property, with items acquired from your house. And
Stephen, could I interject quickly before you move on to the exceptions? I think back to the submissions in August 2017, when Advocate Nick Matsoukas, who comes from the music industry, said a very interesting thing. He said about musicians, he said, copyright is the musician's penny. That's the penny that he has to trade with. If you take that copyright away, the musician does not have a penny to trade with. That applies equally to authors. A copyright is the penny for all creators. I thought that was a very good thing. I thought I should just mention that here.
Thank you, Andre. It's very pertinent indeed. And, you know, for musicians, for authors, that's for me, as a copyright lawyer, the main thing to understand is how powerful copyright is, and that you are the copyright owner when you create the work. And like a physical house, you can only sell it through a written deed of assignment. So you've got the title deed, the Copyright Act says you are the owner. And if you want to license certain rights or to sell it to someone else, it needs to be done by written agreement. So it's an incredibly empowering right, the set of rights. It's a bundle of rights. It allows you to decide who will reproduce the work, who will distribute, who will actually make the work available, under what circumstances and terms, who will be authorized to adapt your literary work into, let's say, a dramatic version of it for film or for theater. So without copyright, you've really got nothing. You don't have any control over the commercialization of your work, and that is why copyright is important. So number one, to protect your rights, and number two, to make sure to also ensure that you've got a right to earn from your work. Without copyright, people will use your works without your permission, and you will not be earning from your works. So when the Copyright Amendment Bill process started, it started a long time ago, around 2011, after a Copyright Review Commission report, which actually started because of creatives, especially in the music industry, stepping forward and saying to government, look, we need more protection. We are actually not earning from our works appropriately. There's too many unauthorized usages made. And one of the biggest problems was the digital age. So nowadays it's so easy for somebody to access your work, with a click of a button, to copy and distribute and send your work all around the world without you maybe even knowing about it. So government, when it decided around that time to update our copyright laws, it wasn't only to to make sure that our laws are modernized, as it was also with a specific focus to make sure that we protect our vulnerable creatives from exploitation in the digital space. That includes authors, that includes musicians, that includes artists, that includes visual artists and performers. Now, at some point from that time when the process started until the first version of the bill was issued by the DTI or made available around 2015, there was a dramatic shift that occurred from protecting authors and protecting creatives to actually promote the interests of users of those works at the cost of authors and other and South Africa's creators. There's been the DTI a week or so before the August 2017 parliamentary hearings announced during a workshop that it held on copyright that it was persuaded to transform our law into a user access oriented system. And that sent alarm bells ringing all around the room. I still remember that day very clearly. Because what we thought initially were errors in drafting, clear errors in drafting that would allow users to share equally in royalty distributions to authors and to musicians and to artists. That was in the first draft version of the bill. We realized then it wasn't a drafting error, it was there intentionally. It was just overstepping the boundaries so far to say that even a person who pays a license fee to an author or a publisher or a musician or their publisher for the use of their work can then run to the back of the value chain and receive an equal distribution of that money that was paid. And then one could see all the other invasive copyright exceptions that really was calculated and intended to disrupt copyright protections in South Africa, to overpower them, to weaken them to a level where the only ones who would benefit from it would be the ones who would make large-scale use of copyright protected works and don't want to pay for that use or don't want to pay market-related royalties, whether they be educational institutions, whether they be government themselves, or whether they be the largest internet platforms in the world that has made a very successful business model off the backs of unpaid labor of South Africa's and other creatives around the world. So now that I've put that out there, we can have a look at, government is free to, like Andre said, to make bad law, right? But then at least be honest about it. At least don't put the bill forward to authors and promote it as a bill that's going to improve their condition. The only thing what authors would have expected to improve their condition was what? Protection in the digital space. And if one looks at what this the Copyright Amendment Bill proposes, it proposes the introduction of the broadest range of copyright exceptions. Exceptions are basically statutory examples, or let's call it, they're instances where a person who relies on an exception in the Act don't have to pay for the author, and in some instances don't even need to recognize the author's paternity, the author's ownership of the original work. So copyright.
Sorry, Stephen. Monica, thank you. May I just jut in there and find out how would you interpret a scenario where an author or somebody is requested to write a textbook for a publisher? Then the name of the author appears on the front page of the book, but the copyright belongs to the publisher and he gets some royalties on that. How would you interpret that when you bring it to copyright? What would you say about it? Because that is what the indigenous language authors are complaining about now, that they are requested to translate or to write for a publisher, but the copyright belongs to the publisher.
Yes,
Sorry to deviate.
Winston, maybe I can jump in there. I've
Sorry, Stephen.
working with the Publishers Association. I've got some background on the different models, and you're absolutely right. When we go back to Stephen's example of your copyright being a house, where the copyright gets assigned, it's one of the things that you as the author can do if you wish, and that is to sell your house. And in copyright law, that is referred to as assignment. And yes, one finds situations where a creator is asked by someone who will publish or produce his work to assign the copyright. Now, it's not always the case. There are probably 4 different kinds of publishing, but certainly that is always the case in educational publishing. So a publisher puts together a book that is going to be used in school syllabuses and so on, and it's part of the existing business model at the moment that because the publisher is putting together the book for the Department of Education, the publisher does play a creative role, and then it subcontracts to various authors to get input into that, and as a result of that, they ask for an assignment of copyright. It's a similar thing when you make a film. If you write a screenplay for a film, the producer of the film has got to collect all the copyrights in one place and ask for an assignment. But on the other hand, if you are a fiction author, like let's say J.K. Rowling or J.M. Coetzee or somebody, you would not assign the copyright. You would have the copyright, but you would have some sort of exclusive arrangement with the publisher or that allows the publisher to make a reproduction of your literary work in order to publish it. Part of the publisher's role, of course, is to sell the book, to collect the money from sales, and then to pay the author royalties on those sales. So there are different models, different situations. Academic publishing, yes, the copyright gets assigned, and also at universities, theses and master's theses, doctoral theses, the copyright gets assigned to the university. And quite frankly, whereas I think this is up to authors to question. So it's not affected by the bill. The issue of the assignment of the ability to assign copyright in works is not affected by the bill. Once an assignment is made, there is a clawback position now, that's a new provision that says that the authors can claim a share in the royalties from the copyright owner. But in the case of literary works, it only says unless otherwise agreed. So in other words, the bill will place authors entirely back in the position that they were in the first place. I think it is up to authors to, in all scenarios, to question when this is necessary and when this is not. If I were to write a thesis for my doctor's thesis for university, I absolutely understand why the university needs to be able to publish my thesis and so on. But I would really ask, why does the university want my copyright? Can you explain that to me? I'm going to give you a license. You can reproduce the way you like because I wrote my thesis for you. But why do you want my copyright? You know, we do have to challenge, we have to ask these questions. I think in educational publishing, it is different, just like it is different in the case of making a film, that in that case, the producer, publisher has to put all the copyrights together in one bundle and come to a different arrangement with its authors. So there you will probably find a sound explanation. If you're a fiction writer in an indigenous language, and you are asked to transfer the copyright to your publisher in respect of a fictional work, I would ask the question, why? So again, Stephen mentioned that nobody researched the application of the changes in copyright to the different copyright industries. But even within the literary industry, there are at least 4 different kinds of copyright where different business models are known and applied. So I hope that answers your question. It is a question authors should be asking, but the bill is not going to improve your situation in that regard.
No, I'm happy that
Thank you.
Everything lies in the hands of the author. That the author, I like what you are saying, that the author should question every step as far as copyright is concerned. Thank you very much. Sorry, Stephen,
If I may,
no, thank you. If I may come in here, I think, Winston, this always happen, like Andres explained, when a book is commissioned. So when they commission you to write, you are writing on their behalf. So that's how the problem rises, because it is the Department of Education that approaches the publishers, and the publishers approaches you in a commissioned work, and that work has their own blueprint that you have to adhere to. So that's why you lose the copyright. I'm just citing that as a common example because it happens for educational books that we write.
I'd like to come in on behalf of ANFASA in this respect. I'd like to add, if I may, to what Andre has said and what Winston and Prof. Ngubane have said as well. It's correct that in law, copyright can only be transferred from the author of the work to elsewhere we call this assignment, and it has to be in writing. And that is not affected by the new Copyright Act. But what I really want to say now is that ANFASA has had many requests from authors asking us questions about their contracts with publishers. And we've run workshops on this, and we are preparing a booklet to explain it. And in the workshops and in the booklet, we advise authors to be very aware of all the clauses in the contracts that they sign with publishers. Does the contract demand that you assign the copyright elsewhere, or do you retain the copyright? This is why it's really important for authors to be knowledgeable about their publishing contracts. And ANFASA has offered help to a lot of authors who are not knowledgeable. And as I've said, we run workshops and we're producing a leaflet. So I hope that authors are going to be more knowledgeable and understanding of their rights in future, and hopefully will become ANFASA members so that we can help them in this respect. Thanks very much.
Thank you very much, Monica. I think we must allow Stephen to proceed with the exception so that authors can raise questions once he finishes his presentation.
Thank you. Back to you, Stephen.
Sorry, Stephen, for disturbing.
No, it's nice. It's supposed to be a dialogue, right? So we welcome questions and comments, certainly. So thank you for that, Winston. I think one can speak all day about the problems in the bill. Andre mentioned at the beginning the submission made by the South African Institute of Intellectual Property Law during the recent hearings on really only constitutional issues, and also where the bill might be internationally non-compliant, because the Portfolio Committee limited the scope of the engagement to the President's reservations. And as Andre also mentioned, there are a lot of other problems that are not necessarily constitutional issues, but that would have dire consequences for trade and investment in our creative sectors. And unfortunately, those proposals that would drastically change how trade and investment can be attracted into South Africa's creative industries were never subjected to any economic impact assessment to show that, yes, here's support for why we want to drastically change things. Now, one of the key areas that affects everyone and also authors is when you look at, like I mentioned at the beginning, what was expected from government when they undertook the task, the very important task of updating and modernizing our copyright law. It was really the focus was to make sure that our authors, our vulnerable creatives, will have more protections, especially in the digital space. Now, if we go and have a look at whether that objective was accomplished, one has to look at the exception clauses. And in there you find, I'm sure that you've all heard the buzzword by now, fair use, the fair use proposal. And a host of other exceptions, new copyright exceptions. And remember, what is the copyright exception? It's that skeleton key that allows someone to walk into your house without permission and to take your property. Now, in certain instances, exceptions are, of course, allowable and appropriate indeed. So at present, as it stands, the South African Copyright Act, in South Africa, we follow what we call a fair dealing regime. Now, fair dealing very clearly stipulates in which instances someone is allowed to walk into your house and take your property without having to ask for permission. So examples of that include research, private study, commenting on current events, criticism, review, etc. Now, most of the countries around the world, and when I say most, the massive majority of countries around the world follow a fair dealing system, where there's it's very clear in law, in the act, the rights holder can go and have a look at the act and see where does it say when someone can enter my house without my permission and take my property without having to pay me, okay? So it helps the rights holder, but it also actually helps the user, because the user will know when and they would be infringing rights and when they need permission. Now, fair use, it's interesting to me, it's become the focal point of the debates on the bill in Parliament. And if you look at the lobbying groups that support that, some of them that support it, it really isn't localized to South Africa. There's a global movement to where some professors and academics are basically as hired guns sent on planes around the world to wherever copyright debates pop up in when a government looks at copyright reform. These folks will magically appear and all of a sudden claim that fair use is the answer to future-proof your legislation, and also to stimulate creativity, and because America relies on a fair use system, and America has a successful creative industry, a vibrant, growing industry, it must logically follow that fair use was the the main contributory factor to that. This is all a bunch of nonsense, really. So if you go and look at, and also claims that fair use is necessary for innovation and for growth. Fair use is not applied in Japan. Fair use is not applied in the European Union. It's not applied in the UK. It's been rejected in more jurisdictions around the world that follow a similar system to South Africa than those that have partially accepted it. In Canada, and Andre can speak a bit more to this due to his knowledge of the publishing industry, the introduction of certain fair use exceptions in the educational space has, and other copyright exceptions, has had dire consequences for their publishing industry. Andre, I don't know if you want to just jump in here to speak briefly to that.
Yeah, so Canada introduced a fair dealing exception, but in the style of a fair use exception, saying fair dealing for the purpose of education is an exception to copyright. So if you're fair dealing with a work and your purpose is education, I think this is really important here. An exception, you do not need the permission of the rights owner, and it's the permission of the rights owner that is the key to payment of the rights owner. So you do not need permission, and therefore there will be no payment. If you are copying or distributing a copyright work for educational purposes in Canada, it has caused untold misery amongst Canadian authors because they've borne the brunt of this. And I think, Monica, we heard from at an ANFASA meeting about, how long ago is it now? But 2, 3, 4 years ago, we heard from the chair of the Canadian Authors Association what direct impact it had on people who wrote in the educational space. The intention of the bill quite clearly is the same. But the bill, in a sense, is even worse, because what is in the bill, as Stephen has spoken about fair use, that's in America. What is in the copyright bill is not exactly the same as what appears in America, but a far broader thing, and where it is specifically said, unlike America, that fair dealing for the purpose of education is, or fair dealing is a permitted purpose for, education is a permitted purpose for fair use. The American law does not say that. There are massive differences between the two provisions. I'm just looking at the time. I see we're getting close to 11 o'clock, and I think after 11 we would like the authors to ask and discuss and speak more. A lot has been written about the fair use provisions and what its impact will be. I would like to turn to some of the other less known provisions, if I may. And a lot of these points were picked up in the Institute's submission as well. So I think firstly, when it comes to before I step off entirely off the topic of exceptions, the Minister has always been empowered in terms of Section 13 of the Copyright Act to issue exceptions to copyright by regulation. And those exceptions, according to Section 13 of the Act, have to be compliant with the requirements of the Berne Convention and the TRIPS treaties, which set a limit to what your exceptions can say. And this is the point about treaty compliance that has been made earlier. So where there are definite needs for copyright exceptions, and I think the most obvious example we've seen, there are already regulations in relation to libraries and in relation to teaching. Where there is a need at this point in time where no provision has been made and where everybody agrees that that need must be fulfilled is for the blind and the visually impaired. Professor Owen Dean has recently written something that appeared in News 24, I think, to the effect that this could have happened years ago. The Minister has the power in terms of Section 13 of the Act to issue regulations that import copyright exceptions as long as they're compliant with our international treaties. So I think this is the last point I would like to make about exceptions before moving on. I think really important for authors are your moral rights, which you get in terms of Section 20 of the Act, the right to be recognized as the author of the work that you've written, and also to object to any distortions. Many of the new exceptions remove that the moral rights to some extent and say that the moral rights or the name of the author shall only have to be stated where practicable. Now, where practicable is going to be determined by the person making the copy. So if the person is making the copy in a format that he can't fit in the name of the author, then he's going to say, sorry, it's not practicable. I'm not going to mention the name of the author. And my message to the authors is that this would be fine in terms of the new bill. It even appears in the new exception for the disabled that the name of the author does not, or only appears where practicable. So in other words, if someone feels, well, it's not practicable, they're not going to put the name of the author in what they call an accessible format copy made under this exception. Now, really, I cannot consider any circumstance ever where a person in good faith who is making an accessible format copy for any disabled person or blind or visually impaired person would ever want to remove the name of the author. Why is that provision in section 19D? It shows there's something else going on here, quite frankly. So if I can turn to some of the other provisions, the bill does bring in the new exclusive rights that's meant to introduce or meant to bring South Africa up to date in the digital age. The right of distribution, the right of communication to the public. These rights relate to the dissemination of literary works through the internet, and they're new exclusive rights that give more power to the author in the context of online uses of their work. However, a huge gap is that these new rights, they're just introduced and full stop. There are no additional enforcement provisions that would help you. You can go to court and say, well, I have the right, but they're in relation to, for example, copying and counterfeiting and so on. The Copyright Act has got certain provisions relating to unauthorized reproduction. Those rights, or those kinds of enforcement rights, have not been extended to the new so-called digital rights. As a matter of fact, they're taking the rights away. The only way that authors have until now been able to enforce their rights in the digital space has been in terms of a completely different act, the Electronic Communications and Transaction Act, which is the responsibility of the Department of Commerce. The bill introduces new provisions that affects the interpretation of these so-called takedown and notice provisions in the Electronic Commerce and Transactions Act. So it's taking rights away. I've also mentioned in response to Winston's question that there are remuneration rights for authors and creators of works, 6A for authors, 7A for artists, 8A for film producers. Certainly in the case, I think that all of them are illusory because they're all dependent on ministerial regulation, and the minister will have to identify what a fair share is, which he may find out being more difficult than he originally thought. But in the case of authors, it's completely illusory because there's this exception to an exception that makes for very difficult reading, but that will allow people to escape from that so-called protection. I don't think that the kinds of protection they inserted here were helpful at all. There are far better examples to follow, say, in the legislation of countries in the European Union to protect the financial interests of authors than 6A, quite frankly. There's another very important provision in a new section 39B, which is a contract override clause. It's the very last clause of the bill, and people, here we've already run out of time, and you then can't get to the last clause, but it is a blanket contract override clause that says you can never contract out of an exception and you can never contract out of remuneration rights. That one single clause can undermine the entire copyright industry. Contract override clauses are, in fact, very useful in relation to very specific exceptions, like, for instance, a text and data mining exception that is often very narrowly crafted, and it relates to situations where there is a contractual relationship between the rights holder and the person wanting to use. And in very narrow cases, a contract override certainly is justified. It is never justified as a blanket overriding clause. So I think that is really there's one last point that you also have to be aware of. The minister is assuming new statutory powers to designate local organizations to take copyright where the work is undertaken under the direction and control of that organization. And this goes back to Winston's question again. The origin of that particular clause is when you do work for the state, when you, apply Professor Ngubane's example, when you take a commission from the state, from a government department to do a certain work, to write a certain work, and you're doing it under their direction and control, the copyright in that work will automatically pass to the state in terms of the law as it has always existed. The same applies to international organizations designated by the minister. Now, the minister has never designated any international organizations ever in terms of this provision, but the intention was to designate entities like the United Nations, the World Health Organization, these big multilateral international organizations. But now, after the word international, the bill throws in the words and local organizations. Now, their authors are in danger because until now, copyright has been their penny. They can negotiate, say, look, I've got the copyright, but I want so much for it, or I'm prepared to give you my penny, but you have to pay me so much. You have the freedom of contract here. In relation to local organizations that will be designated by the minister, you do not have that freedom. If they designate the SABC or the Medicines Control Council or one of those entities as a local organization, you lose your copyright in terms of the bill, and there's no justification for it. Finally, everything was meant to be sorted out by a tribunal. That's also one of the last provisions of the bill. There is no funding authorized for that tribunal. The document that was presented internally as a socio-economic impact assessment said, we will have to find funding. There was no budget, nothing. We don't know what that tribunal is going to cost. That tribunal is meant to safeguard the interests of authors, and there's no funding for it. So you actually cannot import this bill before that tribunal is actually up and running, and one needs to find funding, and they have not followed the internal processes to budget funding for it. So I think that's the end of my legal part of it. Stephen, you mentioned the professors flying around, and in your oral presentation, you made some interesting points about certain professors and doctors and so on had pretty direct access to the portfolio committee that nobody in the copyright industry's ever had.
Yes, Andre, and I believe that is one of the biggest problems that plagued this entire copyright reform project, is the over-reliance by DTI when they took advice and started drafting the legislation on the advice of a small group of academics who hold fringe views on copyright and are not even considered to be copyright experts in their own countries, wherever they hail from. We've seen folks from the United States and elsewhere chime in, as they do, as I mentioned, whenever the issue of copyright comes up. What we've seen is, you know, when one considers the Copyright Amendment Bill, it's sometimes, I think, it's such a comprehensive amendment to the Act that sometimes you think of things like fair use in isolation, or you look at the invasive copyright exceptions that are proposed in the bill that would effectively potentially destroy the educational market for authors who write for that space. And I understand from that the majority of authors, and Monica can correct me if I'm wrong, but the majority of authors in South Africa who write for a living consider the educational market to be a legitimate market where they make their livelihoods. Monica, you can just sort of nod if is that correct? Okay, thanks. So when you have provisions that says that if government or educational institutions disagrees with you on price as the author on your textbook and finds that the price is unreasonable, then government or the educational institution concerned can go away and freely copy and distribute and do basically what they want and include your work in course packs and materials. You know, when you have a provision, like an invasive provision like that, without proper economic impact assessment, policy underlying justifiable policy objectives, you're actually saying you can't any longer say that this bill serves the interests of authors. If the majority of people who earn a living from works in the educational space might lose their ability to earn from and monetize their works. So in essence, you have to look at the broader picture and how it all fits in. And I do know we don't have much time available today to discuss, but I just want to highlight this point for you. Remember, I mentioned at the beginning that clearly one of the primary goals was not only to update the legislation, to modernize it to meet the challenges of the digital age, as people keep saying, but it was also to improve the plight and position of our creatives, of our authors, our musicians, our artists. That was one of the stated policy objectives in the memorandum of the bill, and government keeps saying during election runs that these bills are going to change your lives. But what actually happens is, if you look at that question that I posed at the beginning, does the bill improve authors' position and other creatives' position in the digital space? Number one, you've got this new fair use proposal, which is judge-made law. Keep that in mind as well. It is a set of provisions that doesn't clearly say when someone can use your work without permission or not pay you. It says if these conditions are met, the judge has to look at the nature of the work, it has to look at the amount that was copied, it has to look whether it was for a non-commercial aspect, or and also the potential substitution effect. It's a series of principles that our courts have never in the history of South Africa had to look at, and we can't look at the USA because we don't share common law with them. Now, what it does is it creates massive uncertainty as to when someone can use or can't use your work without having to pay you. And the only way that you can get certainty is to go to court. Now, which of our authors have the money to pay hundreds of thousands of rands to go to the High Court, to see the matter through appeals? And you can just look at what happens in the United States with fair use. There's decades-long litigation. It's appeal after appeal, and it's just the biggest companies that can afford that litigation. Now, the question is not like some of these academics who advance fair use, how they do. It's not a question of whether does fair use in name exist in America. The question is that proposal, like Andre mentioned, that's very different to the US proposal, just shares the same name and a set of vague criteria. Is that right for South Africa, given the state of South African existing law and given the vulnerable position of our authors and our creatives. Does it actually allow our authors and creatives to act against the biggest users of their works that don't want to pay or pay market-related royalties for their work? That's the question. Now, consider this for a moment. In South Africa's law, as it stands, you have to go and prove in a court that somebody, the person who used your work without paying you, without permission, without even mentioning your name, accrediting you, you have to show that that person had guilty knowledge before you can sue them for damages, okay? Now, if you were to introduce this fair use legal defense, what is a defendant in a court case going to say? He's going to say, hang on, I'm holding up the fair use defense and I don't have guilty knowledge until you knock down this legal defense in a courtroom. And then the poor author, well, not necessarily impecunious author, but the unfortunate position of the author and the musician and the other creative is that you have to see the matter through to litigation. You have to go to the High Court. You have to get a judge order that that fair use defense didn't apply. And when the judge does that, this defendant is going to say, oh, okay, judge, now I know that I had no right to use the work. So I cannot be attributed to have had guilty knowledge before this point. Therefore, I should not be liable for damages to pay to this person because in terms of South African law, it's required that I have a guilty knowledge for any infringement done to that point where it can be attributed. So what this means is that why is it deemed necessary to change our law from a very clear set of exceptions to copyright that were well crafted, that were held to be constitutionally compliant, and that are compliant with the Berne three-step test, the International Berne Convention? Why is there this burning desire to turn this on its head and to say, let's add in this vague set of rules that our creatives, if they want to litigate on it, let them go to court. But who does that benefit? It benefits only the largest users of copyright protected materials who either don't want to pay you or don't want to pay you what you are worth. And when we say don't want to pay you what you are worth, remember that provision I mentioned, the educational exception that says if government or educational institutions disagree with you on the price of your book, they don't have to pay it. In fact, they don't have to pay anything. They can just distribute and copy and do with it what they want at that point. Now, it all ties in together. All of these new copyright exceptions and fair use, like Andre mentioned, is extended to the benefit of internet companies through a proposed amendment of the Electronic Communications and Transactions Act, which doesn't, there's no indication before us that the department that is responsible for that piece of legislation, the Department of Communications and Digital Technologies, was ever consulted on this proposed change to actually apply all of the copyright exceptions to the benefit of internet companies and ISPs insofar as takedown notices and things like that is concerned. And then
Stephen, sorry,
yeah.
I see we've got 15 minutes left, and I see there has been one question on the chat here. Could you quickly wrap up, and then we'll check on the question there.
Sure, thank you, Andre. I always need somebody like you, Andre, to rein me in. Otherwise, I'm just gonna keep going. So, then you also have to just bear that in mind, and then also look at, these are all the little clues to tell you what's actually going on. So then you look at the fact that digital rights haven't been extended to, like Andre mentioned, the digital rights of making available, distribution, communication to the public haven't been extended to cover rights holders of published editions. Why not? No indication, just quiet on that one. And if you look at this in its totality, what you're left with is a lie. It really is a bold-faced lie to authors, to creatives, that this bill is going to improve your right to protect your work, your ability to protect against unauthorized usages, and your right to earn from your work, which in a way copyright has been unfairly pitted against public interest rights. It is in the public interest for copyright to be respected, because copyright is the incentive to get you to write as an author. And without your ability to protect your right to earn, you won't write the next book. I've spoken to many authors who write in the educational space who said, we are not going to write another edition of this book for this syllabus until such time as we have clarity on the copyright bill. If this thing comes in, we'll go overseas and write for someone else. So this copyright bill is what can be referred to as a single generation solution. Yes, some money can be saved in the interim, but the next generations will suffer. Thank you, Andre.
Stephen, I have to stop you there. Okay, so we have two questions relating to practice in publishing. The one came from Joseph Masilo, who commented on what Helen Moffat told us about one of the considerations when you would think perhaps of assigning or giving a long-term exclusive right to a publisher, and namely that it is the publisher that takes the risk. The way all the business models work is that the authors take no risk. It's the publisher that takes the risk. And yes, there is an assignment, or there could be an exclusive license, but at the end of the day, if the book doesn't sell, it's not that the publisher is going to come to the author and ask for the costs back. So Joseph raised a question here. Just find it, that you wanted to do a follow-up with regard to a legal question that has arisen. Joseph Masilo. Joseph, still on the call. Okay, I don't see Joseph. Okay, I just had a question. Where are we now with regard to the copyright amendment bill? The answer to
Andre,
that. Yes.
If I may come in, Andre, look, these are very important, legitimate questions that Helen has raised and that authors are concerned with. But given that we're very, very short of time and we have such a lot to talk about the bill, let me say that these are questions that ANFASA deals with all the time. Bring those questions to us and we will answer them for you in a different forum. Let's focus on the copyright amendment bill at the moment, especially, as I said, because we're running out of time. But I've got a question, Andre, and that is, very important things have been said in today's meeting, we've all heard it. But my question is, what can we do to halt the progress of this very damaging bill through the parliamentary process? The committee, the Parliamentary Portfolio Committee, in the public hearings said repeatedly to the public, give us solutions. We've got to find solutions to this dilemma wherein we've got to fix the bill. So my question is, what solutions can we give them? How can we intervene and do something about this copyright amendment bill?
Okay, let me, it sort of ties in that with the question that Mboniseni just asked. Let me quickly go back to Julie Grant, who asked if a book is published by a UK publisher but distributed, I assume South African copyright would apply. That is correct. So the amendment is passed. It will encourage authors to work with South African publishers. Personally, subjective opinion, I think that's absolutely right. Authors may well want to prefer to especially if they have an overseas market, that may well be an effect. There's also another perverse effect arising from the educational exceptions, and that is that you may be contributing to a publisher's educational work, And the government might say, well, we don't need this anymore. In terms of Schedule 2 to the Act, which is another long story, we are going to import works, so they can use the exceptions to import works at lower cost, at a cost that they basically determine. So there's another danger, but yes, and if authors are working with non-South African publishers, what is that going to do to the booksellers? South African books are going to become more and more expensive as South African publishers no longer can rely on educational income. South African books, therefore, fiction and non-fiction books, my subjective opinion, I'm not an economics expert, are going to become more expensive. Exclusive books will come to the conclusion that that imported books may well be less expensive to sell on retail. So none of this has been thought through. I'm speculating, I may be totally wrong, but these are questions that have to be asked. Mboniseni asked, where are we now with the bill? The bill is not on hold. We made submissions on constitutional and international treaty compliance back in July and August. Those submissions will now be considered over the month of November. It kicks off with a feedback given by the Parliamentary Legal Advisor and the DTI on the 9th of November. It'd be very interesting to hear what they say. And based on that, Parliament is going to consider what to do next. This is still in the National Assembly. So following a rejection by the President. So the entire Parliament has already resolved that this is now a bill that has to go through the provinces. What it means is that the National Assembly, the lower house, has to pass the bill again. It is theoretically possible that between what has been shown by ANFASA, by the Institute, and by many, many others, it is theoretically possible that the National Assembly could come to the conclusion that they are dealing with a constitutional nightmare and that they have to reject the bill, send it back to the DTI for redrafting, and that would bring the bill to an end. I think that is, I don't think that is necessarily very likely. I think there will be a couple of more changes that will retain the bulk of the exceptions, but they do realize that certain changes have to be made, and they will pass that changed bill again, after which it will go to the National Council of Provinces, and where it will be considered by the provinces, and where the provinces will have full consultation on the bill. And this is where it's very important that authors come in again. The National Council of Provinces does not have the power to reject the bill. So how the voting will work is that there are 9 provinces, and each province will have 1 vote following their own internal consultation processes. And even if they were to vote against it, then it only leads to a mediation process. It doesn't lead to a rejection of the bill. The point is that there's still quite a long way to walk. That's going to probably take more than a year to finalize, but it is something that authors have to keep an eye on. So authors, so Monica, that means back to your question, what can authors do? Yes, one continues to follow the process. One keeps a watch on what is happening in the Portfolio Committee in the National Assembly at the moment. One makes comments where one can, in the expectation that this is going to the National Council of Provinces. You prepare for submissions before the NCOP Select Committee, as well as in each and every province. I think you should demand public participation in every province, definitely those provinces that have a strong creative representation, not only authors, but film as well. Thinking of Gauteng, KZN, especially, and the Western Cape. But sitting here as a sort of an independent guy who sort of walks his dog, the one thing that I find missing is the outrage. I'm a professional person. I'm not an author. I really look up at people who write well. And here, all of these things have happened that Stephen has described in terrible detail. And I ask myself, but where is the outrage? Authors do need to become more engaged. Monica, as you said, they do need to work to understand copyright better, and they do need to weigh up for themselves what the implications are, and to be very aware of the politics that are swirling around this thing. That's my closing words on that.
How are you?
Thank you. Andre, are there any other questions? Any urgent questions? We are nearly at the very end of our time. It's 26 minutes past 11.
May I make one more point?
Yes,
There's
please.
been a court case in Pretoria, Blind SA versus the Minister of Trade and Industry and Parliament. In terms of that court case, before a single judge, many of you might have heard of it, the Copyright Act was supposedly declared to be unconstitutional because it did not cater for the needs of the blind. It is now 6 weeks later, and neither the order of the court nor the judgment are yet available. This is very important because the order has to be confirmed by the Constitutional Court. That order of the single judge in Pretoria is not sufficient. We find it to be a very, very strange case. Nobody opposed it because nobody is against, it was very clear from the previous consultations, nobody is against an exception for the blind. But the strange thing is that Blind SA said they could have chosen any words to insert in the reading of the law to benefit the visually impaired. But they chose to use Section 19 of the Copyright Amendment Bill with its limitation of authors' moral rights. And you will recall that I said, why? What have they got against an author's right to be identified as the author of his work? I found it to be a very unprofessional ask. They made a couple of mistakes in the order that they sought. It's now got to go to the Constitutional Court. The Constitutional Court role is full until the end of the year, so this will only come again next year. But if you hear people going around saying the Copyright Act is unconstitutional, I would take that statement with a barrel of salt. So yes, there's been an order by a single judge. There are problems with the order in the judge's own chambers, so far as we can determine, and the Constitutional Court still has to approve it. So it is something that we have to watch. But we believe, and Professor Owen Dean has already written in his article, that there are better and more immediate solutions for the visually impaired than making a show trial like this particular case.
Thank you, Andre, and thank you, Stephen. Thank you both for your brilliant contribution to today's conversation. I hope that it's, thank you for speaking so clearly about a very complex and difficult to understand bill. And I think it's been a great benefit to all of us. Sorry, something's popped up on my laptop. Thank you again. Before we close, I'd like to hand over, as promised, to Winston Mohapi, who had something to say, but who is also going to close the meeting for us on behalf of ANFASA. Winston, over to you.
Oh, yes, I'm around. And I must say that this was a very fruitful meeting for us all. And the presenters also will realize that there is much that the public and the authors do not know about the copyright bill, which I think we need more, and FASA will have to plan again something like this, a meeting like this, so that we get more of the authors to know and to understand the meaning of copyright if it becomes an act, what is entailed in the act. When Monica started speaking, I would like to say I really appreciated what she said, that copyright is a complex subject. And you'll agree with me that as Andre and Stephen made their presentations, one could realize that it's really complex. It needs legal minds like Stephen and Andre to untangle the meaning and the implications of the copyright bill before it becomes an act. And I so wish that it should not be hurried to become an act before most of the authors are satisfied with its precepts. ANFASA would like to thank everybody for having attended this meeting. I say attended, of course, we are at different places, but we do, all of us have attended this meeting. But ANFASA would have enjoyed more if the indigenous languages authors were in great numbers than we have today. And we thank those who are here today. And FASA has always made sure that this is a platform for indigenous languages authors so that they can be informed more on what they are involved in, that is in creative writing. And I must say, I wouldn't like to use the word ignorant, but there's a lot of ignorance, if you understand what I mean, lack of knowledge when it comes to indigenous languages authors. I'm not looking down upon them, but you will understand that the education that they received in the past was not conducive to them understanding quite a number of issues as far as literature, the writing of literature is concerned. So ANFASA has seen to it that this opportunity is presented to them, and we will go on having conversations with authors on various topics. And we thank you very much. Let me say that the presentations of Andre and Stephen, now you say I start with Andre, I'm following the first names alphabetic order, A, Andre, Stephen, S. Andre and Stephen, you were great because you've got really a lot of information that needs to be understood, that needs to be followed, interpreted, and I don't know where to access it, you know, not purely as you know it, but one would have liked, and ANFASA maybe will discuss this in our meeting, that somehow we need a booklet that can guide the authors on the Copyright Act when it's finally approved, so that we can access information at any given time on our own as authors. And probably looking into the future, that booklet can be translated by ANFASA. So in other words, what I'm implying is that we may have a collaboration between the two of you in publishing something like that. May I thank you all for having, again, I'm saying, for attending the meeting. And remember, I like the words of Stephen when he said, it is a lie to say copyright bill protects you as an author. I would like to thank you. And may I say, Chairperson, Professor Ngubane, may I close the meeting, or would you like to say something? Thank you.
No, thank you very much. I just wanted to thank you for making these closing remarks and also caution you that these guys, Andre and Stephen, they don't come for free. If you want them to collaborate, they will charge us. And we appreciate that they are here for free. These guys charge you even for making a phone call to them, you pay. But we really appreciate your concluding remarks and that Winston. And also thank you very much for our guests. And we also have a brother from our sister organization, Zana from Zimbabwe, Samuel Makore, who is also in attendance. And we had Advocate Robin Selal from University here in Durban, who also attended. And to all of you, thank you very much. And Baya Danki and Dot Sins.
Yes,
Chairperson, Professor.
Chairperson, may I also say just thank you to the Chief Director, Lisa Comring. She attended the meeting. And thank you, Lisa, for being present today. I'm pointing out to Lisa because we have to, we will in future talk to her about this copyright business. Thank you. Bye.
That's it. Bye, Danki.
Bye, everybody.
Yes, bye.
Thank
you.
Hey,
Thank you.
Bye.
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 Gabotsi.
No, we've done it.
Yeah, hey. Hey, okay, siyabonga.
Siyabonga, sisakhuluma.
Sisakhuluma ngikhala ngalaba abantu be-AXA laba, baningi abantu nabachitha nina ababezolethela imali la kwinhlangano. Nabachitha.
Yeah, I see.
Winston.
Samu.
Winston.
Yes.
Winston Dumela.
Francis Edinyane. You know this guy. I have recommended him to join as ANFASA, and he has done so. And I forgot to talk about him. Thank you very much, Wanesu. Thank you very much. And now you are a no, I saw your name. You are a full member now. Hello. I can hear you, Peter.
Peter. You only acknowledge Ulisa Fela.
Peter Mashamba from Johannesburg or Peter.
Mara degili deginta. Ite.
Mara outside isi photo. Tingu ipatile spati. You must show your face. You must show your face. We want to see you.
One point.
There you are, Peter. Peter, una lady te do Peter is working with Lisa Comrade.
Oh, yeah. Okay.
Yeah, that is the man that we must contact every time we want to talk about.
Is Peter who? What's your last name?
Wabona.
Mashangwane.
Mashangwani.
Okay.
Wabona?
Yeah. Nice to
Yes.
meet you.
Nice to meet you, bro.
Yeah.
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 So Peter, sorry about that, but Narasa Peter.
No, kita nothing in that.
Yeah, you must always show your face. We want to see those wonderful faces, man. Like Samu's face there, you can see him now.
You want to
But
see
you
my
just
face
look
as
at
well?
her and nothing else, You look at her only.
Thank you,
Hey,
Dad.
colleagues, thank you very much. I must leave.
Bye-bye. Bye.
Eh,
Bye-bye.
eh,
Say two, Jika. Bye-bye. Say two.
Peter,
Hey,
Masangwan,
Franz. Ebo.
France.
who's it?
France.
Who's it?
France.
Me bro, Ruzet.
France.
What's up,
I
Eric?
just want to say, want to see you.
Okay, Eric can Tomon, Kivatan Toman, Nikili Moadara seminar, but let me get a picture now quickly. Masangwan Usapumuna.
Kisha hapo mwana mara tabolela kinyo kwa attend a meeting no mu no ne.
I wanna hope he's a haggy meeting to Safele.
Who busy man.
That
Mara tabu akina le number
Hello,
ga mo.
Hello, France.
Tabua Sapana Tatam.
Yeah,
thank
when I bua every day, Lipita Kibua Lena every day.
Okay. No,
Eh,
that's my Tabu, I never tata here.
That is say two.
Which what am I?
Man,
That is say too.
he owns a unsality. He owns that jika. Unsa in the game mon. Was mine. Eh. Fine. Le boni samu here. Le money again.
Hey.
Yeah, but you end there. No more.
That my happy end up there no more. No,
Yeah,
what's
but
that
Samu,
happy?
Samu, thank you for the. We forgot that. Thank you for the platform, for everybody to be in the. No, but we don't hear your voice.
It doesn't want me to speak, I guess.
Now we hear you, Samu. We
Yeah.
hear you.
Okay, thanks. Thank you, everyone. I'm going to close the meeting now.
Thank you.
Thank
Bye-bye.
you for coming through. Bye.
Thank you, bye. That's my happy tabulela, Brajupi.
Retabua.
Thank you.